The most common adoption we get involved with is a so-called step-parent adoption. This is where a person who has a child naturally and has now gotten engaged with a new partner, a person who may be a husband or wife of the natural parent, and they want to make an intact family, and they want to adopt the child. By they, I mean the new partner wants to adopt the child who's the natural child of the other partner. This step-parent adoption is not an unusual process, and it gives people a good feeling, and it will often work. It's important to note, however, that when you want to do that kind of adoption, the natural other parent, for example, if it's the mother whose new husband might want to adopt the child, her former husband or the former father, who's the natural other parent, has a right to stake a claim and object to the adoption if they want to. And for good cause, they might actually be able to prevent it. Well, you don't take chances. Pennsylvania is very careful, unlike some states. In Pennsylvania, if you're going to do an adoption, one of the first things the lawyer has to do is send a notice out to the other natural parent, telling them what you're doing, showing the paperwork, asking them to take the time to think about it, and to consent if they're going to. And if they do that and consent, then you go ahead and proceed with it. And the proceedings, after you do the technical things you have to do in the meantime, there are other techniques that you have to take care of, will be a mere formality. It'll be a nice trip to court, a short hearing. At the end, it's not unusual to have the judge pose with the new intact family for pictures, and everybody's happy. However, when the other natural parent objects, that can create a contested adoption, which is not fun for anybody and can be a very difficult procedure and far from a sure thing. If you are looking to do an adoption and the other parent is perhaps not a very good parent, has issues, criminal record, abuse issues, sexual proclivities that are not good for the child, things of that sort, you'll probably come out all right. But even worse than that is the situation that arises when the natural other parent is in parts unknown and can no longer be found. When that happens, you just can't say, oh, well, they've disappeared, we'll get this done, and it's not our problem, they couldn't be found. They have a right to be notified, or at least you have an obligation to try to notify them. In that instance, you have to do what's called an alternate service. And depending upon which county you're proceeding in, for example, Philadelphia and Bucks County have different ways of satisfying that. You will find that it can become a costly venture and a not easy one to accomplish. For example, if it's going to be Bucks County, under current rules, first you have to go to the trouble of trying to actually find the other parent. You send notices out to the Department of Vital Statistics, the Voter Registration Bureau, the driver's license folks, people who might know where that person might still be, might have records for them, and you send that to the location of last known address. Well, if the last known address is more than one location, oh, the wife may say to you, well, my ex-husband lived in Philadelphia, but for a while there, he lived in Morristown, New Jersey too. You might have to go search both places to go try to find the person. And after you've gone to the effort of doing that, then you have to have a request for a hearing at which you will demonstrate you did the things you had to do to find the person. And if you're granting a right to do that, they'll let you do the alternate service. In Bucks County, that will require, in the modern internet age, that you advertise it in the paper, which is a very, very costly procedure. And then will, having that been done, you will then have done the best you could to serve notice, and you go proceed. It would be a good idea anyway to send a certified letter to the last known address and have it come back unclaimed, so you really tried. In some jurisdictions, not advertising, you can simply do the last known address certified mail. It varies. In any event, once you've done all that, assuming there's no competition and no contest, the adoption will go through. You'll get a brand new birth certificate with a new name on it, and you will be free to live a life, and the judge will routinely make a speech to the new adoptive parent that essentially says, well, you're a natural parent now and have all the obligations and responsibilities as if you always were, which can include things like maintenance and caring for the child, or God forbid things go wrong in the current relationship, things like child support can be caught home to roost as well. Nevertheless, it's a good thing. I always say that people who come to see me very often are not in a very good mood. This is one of the nicer things we do here. And it can be very complicated. I can tell you that in any jurisdiction that adoptions are done of this type, they are technical in nature. The court's very, very careful. No mistakes are made and everything is exactly right because they're taking away the rights of a natural parent if it works. And nobody wants to read about themselves in the newspaper having done things wrong. And as a consequence, they can make things very trying for you to file papers and have it come back. You didn't do this right. You didn't do that right. You didn't understand this is the rule. And the rules sometimes change and you're not aware of it. So it's not something that ordinarily, though it's doable, a person should try to do by themselves. After all, we're talking about your life, your money, and your property. When it really matters, the choice is simple. When it really matters, the choice is simple.